Now we consider judicial review. This is the first big, broad area of constitutional law. It also is an area that is lightly tested. You might get a couple of questions on the MBE about this material, and some of this stuff might be involved in an essay, but it's very unlikely that this area of law is going to contain a great deal of points on any given bar examination. As we consider judicial review, there are three broad areas that we'll be considering: the organization of the court system, jurisdiction of the various courts within that system, and then we'll spend a few minutes considering how judicial review really works in the world, judicial review in action. So, to begin with, let's ease our way into constitutional law by considering how the courts are organized and how the relationship of the courts in the federal and state systems relate to one another. We consider first federal court jurisdiction, and then we'll consider state court jurisdiction. With regard to federal court jurisdiction, keep in mind that the 11th Amendment is going to prohibit citizen suits against a state in federal court, although, as we know, a citizen can sue a state official in his or her capacity and litigate the issues that way. We know that the federal court often will abstain from hearing cases, and the abstention doctrine is the source of an occasional question or two on various bar exams. Realize that the federal courts can abstain from deciding a case if there is a state law issue that is going to be decided by a state appellate court at some time in the reasonably foreseeable future. If there is a way that the federal court can escape having to make a decision based on relying on future state court action, that's a justification for the federal court abstaining from taking on a particular case. Also, keep in mind that the federal government will abstain from hearing the appeal of a criminal case where that criminal prosecution already has been commenced. If we've got a situation where the state is considering filing a criminal case in state court, it is conceivable that a litigant can take the issue to the federal system first, but if the state has already filed charges, the federal court is going to abstain until the state proceedings are completed. The federal court is patient. They will wait their turn under those circumstances. Okay, that's the big, broad picture of federal court jurisdiction as we consider the organization of the court system. State court jurisdiction is much less tested on con law essay questions, and it is much more heavily tested in civil procedure. That's where state litigation rules really belong on a civil procedure examination. But keep in mind that there are a few details that have been tested about state court jurisdiction as it relates to federal constitutional law. Remember that Congress has the authority to require state courts to hear cases that are based on federal statutes. That's within the authority of the federal system. Congress can insist that state courts hear particular cases. Also, political subdivisions of a state aren't protected from suit against under the 11th Amendment, and so it's okay for various subdivisions of a state, municipalities and other small jurisdictions within a state, to be defendants without it violating the 11th Amendment. Also, one final detail, which I think may have been tested once or twice in the last generation, is when one state has a claim against another state, that claim goes directly to the United States Supreme Court. Interstate disputes have their original jurisdiction in the U.S. Supreme Court. And as you watch this video, unless you are a specialist in this area of law, I bet you can't even think of a single case from all of your studies that involves State A versus State B in front of the U.S. Supreme Court. So that's a pretty good reason to suspect that this is not a highly tested issue. Still, it is on the outline. It is worth knowing. So now let's consider the jurisdiction issues within judicial review in a little bit more depth. In order to have a case, the court has to have jurisdiction, obviously. That's as true here in con law as it is in civil procedure. There has to be a constitutional basis for that jurisdiction. Typically, the jurisdiction will arise either from original jurisdiction or from appellate jurisdiction over the lower federal court decisions. So as we're considering jurisdiction here, what we're thinking about is federal court jurisdiction. Next, we consider the congressional power to define and limit jurisdiction within the federal courts. And this is an area that brushes right up against separation of powers issues. We know that Congress has got the power to define and limit the Supreme Court jurisdiction, the jurisdiction of the lower courts, and also the jurisdiction of the Article I courts. But keep in mind that although it is true that Congress can establish and abolish the lower courts and can control jurisdiction over those courts, the line is drawn fairly brightly at the point where Congress seeks to interfere with the judicial branch's role in constitutional order. Congress has got a lot of authority over the federal courts, but it doesn't have any authority to thwart or prevent the federal courts from playing their appropriate role in our three-branch government system. So, with all of that in mind, let's spend the last few minutes of this short video considering judicial review in action. Let's look at how judicial review actually works. And again, keep in mind that this is relevant material, but it isn't hugely important. You might get a question or two on the MBE from the issues that are contained in this entire video. It's very unlikely that the issues that come out of this part of the outline would make up a substantial part of the essay. Still, it is material that's well worth knowing, and it does provide a good background for a lot of the issues that follow. So, as we consider judicial review in action, keep in mind that there has to be a real dispute in order for there to be anything for the courts to review. There has to be a case and controversy shown. In other words, the requirement is that there be a case and controversy. That means that the plaintiff has to show standing, the dispute has to be ripe, and it has to not be mute. And here, there are a couple of issues that are almost ritualistically tested. A couple of ideas that nobody would be surprised if you saw them on the next bar examination. First, this idea of ripeness. If we know that there are a series of material facts that are relevant to a case, and one of those material facts hasn't arisen yet, that case is not yet ripe for review. Here's an example. Suppose we've got somebody who wants to claim an unconstitutional discrimination. Somebody wishes to bring an equal protection claim, and they can bring to court a lot of evidence showing abusive or discriminatory statements made by various bureaucrats. But suppose that plaintiff cannot yet show that all of these discriminatory statements add up to an act of discrimination. Suppose we've got somebody who's got a job application or a school application pending, and that application has not yet been denied. It may very well be that everybody knows it's going to be denied, but until it has been denied, the case technically isn't ripe, and a federal court will be unlikely to hear a case that isn't genuinely ripe for review. Also, we know that cases can't be moot, but we will see in our practice together that where a case can readily be repeated, where it is subject to repetition, a court will not dismiss that dispute merely because the instant facts suggest that it is moot. If all of the issues are ripe for review and the problem that is at the core of the dispute readily can be repeated, a court will likely take the case despite defense claims that it is moot. Next, the issue of justiciability arises. And here, the courts will be shy about taking on cases that really are political disputes. The courts are where we are trying to resolve what the law is, and sometimes a decision will be used as a justification for political action. But the purpose of the courts is not to resolve political disputes. That's what the political arena is for. So in court, there must be a legal issue that is justiciable. We're going to stay away from political questions. Also, keep in mind that the federal appellate courts are available to review state court decisions where there is an impact on the federal law. Also, here in constitutional law, we also consider a few issues that we would think would have a little more to do with civil procedure. For example, the burden of proof. Where we've got a litigant, a plaintiff, who seeks to establish the unconstitutionality of a statute, it is the plaintiff who bears the burden of proof with regard to that issue. Also, keep in mind that rational basis is the ordinary standard, the most common standard for reviewing due process and equal protection. It's only in special cases that an elevated standard of review is appropriate. So here, I would analogize between constitutional law and negligence. In negligence, the reasonable person standard is the general standard that always applies, unless some higher standard applies. So with regard to judicial review, the rational basis test is the standard of review, unless specific facts give rise to one of the elevated standards of review. And one of your jobs as you prepare for the examination is to master the different standards of review. And the best way to do that is not through watching a video or reading an outline. The best way to do it is by working through hypothetical questions that require the application of these standards. That's the best way to learn the standards of review. We'll go over them in a fair amount of detail, both here substantively and again later in our hypotheticals. But the standards of review are probably one of the most important facets of the core information from constitutional law. Also, remember that the compelling state interest, or the strict scrutiny standard, is the standard that applies whenever a fundamental right or a suspect class is involved in the litigation. So, remember, rational basis is the threshold standard. Where special facts are present, the standard can be elevated to strict scrutiny or the compelling state interest standard. A very quick review of the three big standards of review. And as we practice, we'll see that we can refine this list a little bit. Strict scrutiny is where we have a compelling state interest plus no less burdensome alternative. Intermediate scrutiny is where we have an important objective on the part of the government and a substantial relationship between the rule in issue and that objective. And the rational basis is basically trying to answer the question, is this statute sane? And if the answer is, yes, it is sane, we'll uphold it. And that wraps up a quick consideration of judicial review. Next, we will consider separation of powers issues.